Welcome to The Docket. I'm your host, Corey Snow. In this episode, we're going to hear the transcript of a motion hearing held in the U.S. District Court in Washington, D.C. on August 11, 2023. This was a hearing on protective order and is interesting because it features direct conversations between Judge Tanya Chutkan, referred to as the court in the transcript, and both the government and defense attorneys. It also serves to signal the defense attorney's potential strategies and Judge Chutkan's refusal to accord Mr. Trump any special treatment. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. United States District Court for the District of Columbia. United States of America, Plaintiff v. Donald J. Trump, Defendant. CR number 23-0257, TSC. Washington, D.C., Friday, August 11, 2023, 10 o'clock a.m. Hearing on protective order before the Honorable Tanya S. Chutkan, United States District Judge. Appearances. For the government, Thomas Wyndham, Esquire. Molly G. Gaston, Esquire. U.S. Attorney's Office, 601 D Street Northwest, Washington, D.C., 20530. For defendant, John F. Lauro, Esquire. Gregory M. Singer, Esquire. Lauro and Singer, 400 North Tampa Street, 15th floor, Tampa, Florida, 33602. Todd Blanche, Esquire. Blanche Law, 99 Wall Street, New York, New York, 10005. Court Reporter, Brian A. Wayne, RPR, CRR, U.S. Courthouse, Room 4704A, 333 Constitution Avenue Northwest, Washington, D.C., 20001. Proceedings reported by stenotype shorthand. Transcript produced by computer-aided transcription. Proceedings. The Deputy Clerk. Good morning, Your Honor. This is criminal case number 23-257, United States of America versus Donald J. Trump. Counsel, please approach the lectern and state your appearances for the record. Mr. Wyndham. Good morning, Your Honor. The Court. Good morning, Mr. Wyndham. Thomas Wyndham and Molly Gaston for the United States. With us at counsel table is FBI Special Agent Jamie Garman. The Court. Good morning. Who will be speaking for the government this morning? Mr. Wyndham. I will, Your Honor. The Court. All right. Thank you. Mr. Lauro. Good morning, Your Honor. Nice to meet you. The Court. Good morning. Mr. Lauro. John Lauro on behalf of President Trump. With me is Todd Blanche, my co-counsel, and also my partner, Greg Singer. The Court. Good morning. And who will be speaking for counsel this morning? Mr. Lauro. I will. The Court. All right. Just so you know, because we're going to be working through this, you all are free to remain at counsel table and seated if you want, just as long as you speak into the microphone so my court reporter can hear you. Even if I can hear you, if you're not on the microphone, he cannot, and he's got to keep the record. So you're welcome to stay at counsel table rather than hop up and down. It's totally up to you. All right. We are here for a hearing regarding the parties' proposed protective orders in this case. The government has moved for imposition of a protective order in ECF number 10, which is frequently used in criminal cases to ensure that certain information that the government shares with the defense is not disclosed to the public. The defense has objected to the government's initial proposed order, and the government then proposed a second order to which the defense also has objections. The parties have been unable to, so far, resolve those objections and reach agreement on their own, and so I decided to schedule this hearing to work through those objections one by one. And I want to thank the parties for making themselves available on such short notice. I know initially I said I wasn't available on Friday, and then I became available. So I really appreciate that because, as you all know, the government can't turn over discovery until there's a protective order in place, and so it's imperative that this be resolved promptly so that discovery can be disclosed and the case can move forward in the regular order. So, a brief word about briefing schedules. Under Local Criminal Rule 47B, a party may oppose a motion within 14 days of the date of service or at such other time as the court may direct. Likewise, under Rule 47D, the default deadline for replies in support of a motion is 7 days after service of the memorandum in opposition. However, I routinely depart from the default 14 and 7-day time limits, as do many of my colleagues, when it serves the interest of justice and efficiency. With respect to the government's pending motion, for instance, I determined that a shorter briefing schedule deadline was appropriate, given the relative brevity of the proposed protective order and the need to proceed with discovery in this case. There may well be other instances and times in this case where my briefing schedule is shorter or longer than the one prescribed in our local rule. And so now I intend to resolve the parties' objections by going through defendant's red line to the government's proposed order one by one as they're set forth in ECF number 14, which is Exhibit A. There's a few minor differences between A and B, but I thought A best. So I am prepared to rule immediately on some of the revisions. For others, I will have some questions. I will have some questions of counsel before I make my decision, and after this hearing, it's my intention to issue a protective order consistent with today's rulings as quickly as possible. So, Federal Rule of Criminal Procedure 16D provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection, or grant other appropriate relief. Under binding D.C. Circuit precedent in United States v. Cordova, 806 F3D1085-1090, the burden of showing good cause is on the party seeking the order, and among the considerations to be taken into account by the court will be the safety of witnesses and others, a particular danger of perjury or witness intimidation, and the protection of information vital to national security. Relatedly, I must also comply with what the Supreme Court has said is my affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity, and that's from Ganetco v. de Pascal, 443 U.S. 368. The Supreme Court noted that after the commencement of the trial itself, inadmissible prejudicial information about a defendant can be kept from a jury by a variety of means. When such information is publicized before the trial, however, it may never be altogether kept from potential jurors. As a result, the Supreme Court stated in Alderman v. United States, 394 U.S. 165-185, that the trial court can and should, where appropriate, place a defendant and his counsel under enforceable orders against unwarranted disclosure of materials which they may be entitled to inspect. Mr. Trump, like every American, has the First Amendment right to free speech, but that right is not absolute. In a criminal case, such as this one, a defendant's free speech is subject to the release conditions imposed at arraignment and must also yield to the orderly administration of justice, especially with respect to disclosure of materials obtained in discovery. Without a protective order, a party could reveal information that would taint the potential jury pool, result in the harassment or intimidation of witnesses or parties in the case, or otherwise prevent a fair trial. Accordingly, I'm going to review each disputed portion of the proposed orders today to ensure that they are consistent with the defendant's rights and the integrity of the judicial process. In other words, that there is good cause for the order that I'll issue. So I want to begin with what is perhaps the party's biggest disagreement, the scope of the protective order. The government proposes that the order govern all discovery material that it turns over to the defense. The defense proposes that the order govern only the materials that the government designates as sensitive. This disagreement is reflected throughout Defendant's Exhibit A, but the most relevant paragraphs are paragraphs 1 and 2. So here I have some questions for you, Mr. Wyndham. In your motion, you stated that there was good cause for your proposal, and I quote, "because issuance of the government's proposed order would expedite the flow of discovery in this case, give the defendant prompt access to a large portion of the discovery he ultimately will receive, and protect the highly sensitive categories of material." But I don't see why those same goals wouldn't be served by the defense proposal. So can you explain why you think there is good cause to cover all discovery materials rather than just sensitive materials? And I have a couple of follow-up. Mr. Wyndham. Yes, Your Honor. Thank you. So that is the kind of larger philosophical difference between the government's proposed order and the defendant's proposed order. The government wants the protective order to cover all discovery. The defense only wants it to cover sensitive discovery. The Court. Right. Mr. Wyndham. On this issue, in addition to the line from our motion that you read, in the paragraph underneath that, it also talks about preventing the improper dissemination or use of discovery materials, including to the public. So the larger basis here is that, under the government's proposed order, it really follows three overlapping bases for good cause. The first one is to ensure that the purpose of discovery is for the fair and efficient adjudication of the court in the courtroom as opposed to in the public. The second is that, consistent with the advisory committee explanation for the purpose of the rule, it is to safeguard witness security, to prevent intimidation of the witnesses, to prevent harm to reputation or dignity of the witnesses, and to prevent personal information from being released, in addition to the third overlapping piece, which, as Your Honor noted, is the court's affirmative duty to prevent prejudicial pretrial publicity. Those are the overlapping three core objectives at which our protective order is aimed and which is, in some respects, different than what the defense has proposed. The defendant's proposal specifically is tailored to permit them to try this case in the media. This is something that Your Honor, in the Rule 57.7 hearing in the Butina case, noted was an improper purpose, to try the case in the media. Here, the defendant is asking for the court's blessing to be able to use criminal discovery for political purposes. That is not a proper use of discovery. And what is, I think, telling is that the defendant's proposed order and the defendant's arguments do not actually indicate any way in which the government's proposed order hinders the defense's use of discovery material in defense of this case in the courtroom. The Court. I hate to interrupt you, Mr. Wyndham, but all that may be so, but how is that explaining why all of this material is both sensitive and non-sensitive? So my question really goes to, what is the good cause shown for subjecting the non-sensitive material to the order? Mr. Wyndham. There is some sensitive material, a great amount of sensitive material that we would designate, and there's some non-sensitive as well. The Court. Right. It's the non-sensitive I'm interested in. Mr. Wyndham. Yes, ma'am. The non-sensitive falls within the exact same rubric that I just laid out. Even if it's non-sensitive, it still may be inadmissible. It may still be irrelevant, but it may be sensational. It may be something that is used by the defense or the defendant to pollute the jury pool, whether purposely or not. The information the defense has set forth both in the defendant's own posts and the defense counsel's statements on the Sunday shows last weekend, the defendant has set forth that they deem, quote, informative, is what the defense counsel said. The Court. Well, defense has a First Amendment right to, within limits, to speak about the case. What I'm interested in is, the circuit says I have to enunciate good cause for protecting information, and certainly I don't see any problem with the sensitive information. Well, let me ask you this. What percentage of the discovery, if you can just give me a rough estimate, is non-sensitive? Mr. Wyndham. Giving you an estimate, Your Honor? The Court. Yes. You said a small amount? Mr. Wyndham. Yes, ma'am. I would say that the vast majority would be designated as sensitive within the government's definition of sensitivity. Obviously, that's an issue of dispute between the parties, but I would say the vast majority. It's hard to give a percentage because some of the discovery material may already be in the defendant's. He may have the right to access the material otherwise. The Court. But that's the sensitive material. Non-sensitive is what I'm focused on. Mr. Wyndham. Yes, ma'am. For the non-sensitive material that the government intends to produce, there is some, obviously, non-sensitive material, which is a fairly small amount. Then there is another bucket of material, which may be up to a quarter of the government's first production, which we need to consult with defense counsel on, because the defendant may have the ability to actually access that information other than us giving it to him. The Court. And would that be sensitive or non-sensitive information under the definition as set forth in the protective order? Mr. Wyndham. Sure. Under the definition, assuming that the defense can affirm in writing that they otherwise are able to access that information, we would not consider it sensitive. We're talking about information specifically from the defendant's campaign entities or PAC entities. The Court. All right. So, if I understand what you're saying, your position is it's even the non-sensitive information could be used for witness intimidation or reputational damage, or, if so, why wouldn't it be sensitive, I guess, Mr. Wyndham? It would not be sensitive within the definitions we have laid out, but it still could be produced in discovery. And then Your Honor mentioned the First Amendment right. As you know, and as you quoted from Seattle Times, there is simply a different calculus when it is discovery that is used in a judicial proceeding. There is much less of a First Amendment issue, and the only thing the court needs to look for, as you've said, is the good cause standard. So I would just go back to the three animating principles they provide for protection for all of the discovery material for the government, both sensitive and non-sensitive. The main thing is, well, it's all important, but as Your Honor said, there is the potential of damaging reputations of witnesses depending on what the non-sensitive information is. It doesn't simply need to include PII in or a witness's statement in order to potentially damage the witness's reputation. But secondly, the larger issue here is the defense has broadcast their strategy, and that is not to try this case in the courtroom, and the court should address that with this protective order. The court: I intend to, but my task here is somewhat narrower. Mr. Wyndham: Sure. The court: And it really focuses on how much... I don't want this order to be over-inclusive. Mr. Wyndham: Yes, ma'am. The court: In other words, I don't want to just issue a blanket protective order over information that is not sensitive. But if you're talking about a small amount relative to what's being turned over, or if you can enunciate good cause, because that is what I have to find. And certainly if I decide to have two categories and not have the non-sensitive information subject to the protective order, you can always go over the non-sensitive and consider if you need to designate it as sensitive. Isn't that right? Mr. Wyndham: That is right. I will put out an additional implication for the fair and efficient administration of this case and getting this case to trial, which I think is an important consideration. The court: Oh, I agree. Mr. Wyndham: Should the court... the government has a blanket approach. The defense has the sensitivity designation or not, or simply outside the protective order. Should the court go with the defense's approach, I anticipate that there will be never-ending battles over sensitivity designations, and perhaps every week we might be before the court in order for the defense to raise an objection as to the government's sensitivity designation. The court: But if the amount of material you're describing as non-sensitive is relatively small, I suspect we're going to be having disagreements about a lot of things in this protective order, but if the non-sensitive material you're describing is relatively small, that is a limited amount of disagreement we could have, isn't it? Mr. Wyndham: I think it's the flip, Your Honor. Since the sensitive amount is so large, under the government's order, if the government produces it in discovery, the defense simply cannot use it on the weekend shows. If the court goes to the defense's proposed order, then there will be the squabbles over what is sensitive. The court: Isn't that going to happen in any event? If I go with your request and designate it all as sensitive, can't the defense come to me through motion and say, we believe this document is not sensitive? Isn't that going to be the case anyway? Mr. Wyndham: The defense could do that, Your Honor, but it would still be covered under the protective order and would not be permitted to be publicly disseminated. The court: Until I ruled otherwise. Mr. Wyndham: Unless you ruled otherwise under paragraph 16 of our proposed protective order. The court: Okay. Mr. Wyndham: The other thing to consider here is that the government will attempt to lay out, this is a decision today, to address what the court sees as good cause and the best interest of this case and the fair administration of justice. Should it prove unworkable for some reason, paragraph 13 permits a modification. Paragraph 16 permits document-specific adjudication by the court. So, for those reasons, the ones that we've set forth as our animating principles for all discovery, sensitive or not, and the potential for what the government believes to be endless litigation over sensitivity designation. So it's whether it's in or outside of a protective order, the government believes that the court should enter our proposed protective order. The court: Thank you, Mr. Wyndham. Mr. Lauro? Mr. Lauro: Yes, Your Honor. I think you hit the nail on the head. The court: That may be the last time you say this for a while. Laughter. Mr. Lauro: I doubt it, Your Honor. But truly, this kind of blanket order is extraordinary. The government has the ability to separate out sensitive and non-sensitive information. We have to face the fact that we are in uncharted waters here, where we have a presidential candidate running for office, and his opponent has the Justice Department bringing criminal charges against him. And in this situation, certainly President Trump has the right to respond and speak about these issues. What we're asking for is for the government to show good cause, as Your Honor has designated those items under Rule 16 as well as the case law. Extrajudicial speech, or public speech, is not one of the good cause factors Your Honor described. The Court. It is a good cause factor if that extrajudicial speech causes witness intimidation or harassment or interferes with... it must always yield. And so what the defendant is currently doing, the fact that he's running a political campaign currently has to yield to the orderly administration of justice. And if that means that he can't say exactly what he wants to say about people who may be witnesses in this case, that's how it's going to have to be. Mr. Lauro. And that's a different issue, though, than a Rule 16 protective order, I believe, because the Court. But isn't a protective order under Rule 16 designed to protect the harassment or intimidation of witnesses or the dissemination of information that is sensitive? Mr. Lauro. Sure. It's directed if there is some cognizable harm or identifiable harm to a particular witness or an issue of perjury. Here we don't have that. The Court. Well, Mr. Lauro, what about talking about a potential witness to a nationwide or potential worldwide audience and denigrating that witness? Isn't that the kind of situation that the protective order is designed and Rule 16 is designed to prevent? Mr. Lauro. Your Honor, you may have Mr. Pence in mind. Is that your concern? Any witness. Mr. Lauro. All right. Well, obviously, on the campaign trail, since the prosecutors decided to bring this case in the middle of the campaign, President Trump has the ability to respond fairly to political opponents, and that's the problem with the way this order is structured. The Court. The defendant's desire to conduct a campaign, to respond to political opponents, has to yield. Do you disagree with that? That there are limits, regardless of what is going on in, I hate to say, his day job? This is a criminal case. The need for this criminal case to proceed in the normal order and protect witnesses and the integrity of the process means that there are going to be limits on the defendant's speech. Mr. Lauro, I can assure you that my client will abide by the integrity of the process, but he also can't be subject to some kind of a contempt trap, which this really is. The Court. I think you're going... nobody's talked about contempt. What we're talking about now are the parameters of this order, and the parameters of the order that we're all considering means that there are certain things, if they have an impact on the administration of justice or on witnesses, can't be said, regardless of what endeavors the defendant is currently engaged in. Mr. Lauro. No one disagrees that any speech that intimidates a witness would be covered by this order and prohibited. What we're talking about, though, is the fair use of information. For example, if my client has a memory of a certain event that occurred and wants to speak publicly about it in the course of a campaign, he's certainly entitled to do that. The Court. Not if that memory ends up containing information that would intimidate a witness. It always has to yield to the fact that there are pretrial release conditions and a protective order will be in place. Mr. Lauro. And he'll abide by that, obviously, and has abided by it. But my concern here is that the first obligation is on the government under Rule 16 to establish what's sensitive and what's not sensitive. The Court. So let's go back to that, because we're kind of painting with a very broad brush here. Let's go back to the designation. Is it your position that, with regard to the non-sensitive information, that your client can say whatever he wants to say about the non-sensitive information? Mr. Lauro. No. Subject to the limitations that you've described, he has to abide by the rules of this court. Certainly he has First Amendment rights, but in no way am I suggesting that any client could ever intimidate a witness or use that information. But we are in the middle of a campaign, and the way this order is structured, it would provide an enormous advantage to President Biden in the middle of a campaign, and that's my concern. It really... The Court. What the effects of my order are on a political campaign are not before me and are not going to influence my decision here. This is a criminal trial. This is going to be a criminal trial brought at the time that the government decided to bring the charges, and they decided they were ready to bring charges. I don't have any control over that, but I cannot and I will not factor into my decisions the effect it's going to have on a political campaign for either side. Mr. Lauro. Although, Your Honor, one of the good cause factors requires you to do the balancing that you described. The Court. Of course. Mr. Lauro. And one of those is the impact on the defendant when you enter this order, and I think, as a result of that, the Court has to balance the factor and the impact on a defendant. The Court. Mr. Lauro, your client has not seemed to have had any trouble talking about the prosecution of this case for some time, and the investigation that he's been under for some time, and the protective order, in many ways, would not infringe on his right to talk about that. Mr. Lauro. And then we have no problem if he can speak the way he's been speaking. The Court. So let's go back to the sensitive versus non-sensitive designation. What would be the burden on the defense if I designated all materials, sensitive and non-sensitive, as subject to the protective order, to the defense simply moving to exempt certain documents? I mean, I suspect we're going to be dealing with discovery disputes occasionally. Mr. Lauro. It would be a massive burden, Your Honor. The Court. Tell me how. Mr. Lauro. Especially when they can designate sensitive versus non-sensitive information. We looked at all the Rule 16 orders that have been added on J6 cases. We haven't seen a single one that resembles this type of order in terms of breadth. I'll give you a practical example. They designate all examples of testimony or interviews or videos as being sensitive, and they require us, as counsel, to sit with our client in the same room while our client reviews that material. The Court. I'm going to get to that. Mr. Lauro. Okay. The Court. I'm going to get to that. Mr. Lauro. But that's just one example of how overburdensome that is. And the other issue is the Court. But that material is already designated as sensitive. I'm not hearing a request to say that material is not included in the sensitive designation. What I'm talking about is the non-sensitive. In other words, are you saying that those witness interviews should not be designated as sensitive? Mr. Lauro. Absolutely they should not be designated. The Court. Okay. I'm going to get to that. Mr. Lauro. Unless the government can come up with good cause as to why. But I think, as you've seen under Rule 16 in your experience and the orders that you've entered, the burden should be on the government. The Court. It is. Mr. Lauro. First, to designate what's sensitive and what's not sensitive. The non-sensitive material is subject to the regular rules of the Court that we all have to abide by in terms of what we can say and what we can't say about it. But that non-sensitive information should not restrict, under the Sixth Amendment, our ability to represent our client, and our ability to have an opportunity to discuss these issues with our client, but also not be required to sit in the same room as we go over a massive amount of documents in this case. The Court. Well, again, I'll get to that. Mr. Lauro. I know we'll get to that, but really the burden is on the government under Rule 16, and here they're trying to switch it. They're trying to say the burden is on President Trump's team when it's not. It really has to be something that the government has to go through and provide good cause. These kinds of blanket orders really present an enormous problem here as well because of the ambiguity in this order. The risk is that someone can say something in the course of a heated debate or heated campaign, and they're going to throw a flag and say, no, wait a minute, somewhere in the bowels of discovery, there was something that mentioned what you just said, and therefore you're in violation of this order. And then we're off to the political spectacle of President Trump in violation of the order. All of this, Your Honor, unfortunately has to be understood in the context under the microscope of how the government decided to proceed. And I will say one other thing. Everything that we do here now is under a microscope, a political microscope, unfortunately, because of the result of what the government has done. And I understand our requirement, and we will obey Your Honor's direction 100%. The Court. I'm glad to hear that. Mr. Lauro, and not ever deviate from what Your Honor directs us to do. But there has to be fair play here. All we're asking for is fairness in terms of how we handle this discovery. We don't even know the magnitude of the discovery yet. They haven't even described it for us. Is it 1 terabyte? Is it 3 terabytes? But the bottom line is we need something that's workable, that isn't ambiguous, that doesn't intrude on the attorney-client privilege, that affords my client the due process rights that he's entitled to in the context of a campaign. We can't ignore the fact that it's a campaign. The Court. I intend to ensure your client is afforded all the rights he's entitled to. I reiterate that the existence of a political campaign is not going to have any bearing on my decision other than, any other lawyer coming before me saying that my client needs to be able to do his job. I will always obviously factor it in, but I intend to keep politics out of this. And, Mr. Wyndham, since you have the burden, I'm going to let you respond to Mr. Lauro. Did I cut you off? Mr. Lauro. No, absolutely not. Your Honor, just in sum, the factors that are at issue here is whether or not the government can show good cause with respect to witness intimidation or perjury. We'll put national security aside because there's no question, no issue there. But they haven't done that yet. They haven't done that in terms of any cognizable or non-speculative harm that exists. The Court. As to the non-sensitive. Mr. Lauro. Exactly. The Court. I keep trying to come back to the paragraph. Mr. Lauro. I understand your difference, and, Your Honor, that's our difference. That's why we wanted the order to separate out sensitive from non-sensitive and put the burden on the prosecutor to come up with what's sensitive at an initial blush. Now, if they put something in the sensitive bucket, we can argue that it shouldn't be. But in fairness, they should have the first obligation to do that and not have this blanket assertion. And one other point that I need to make on paragraph 1 before I forget, if I may, Your Honor. It says, the order does not apply to records, and we should add, or information. Records or information, because that covers the Seattle Times issue where a client who is subject to a protective order may have some information from prior that's not connected to the discovery process. The Court. Well, isn't that covered by another paragraph? Mr. Lauro. It's not really, and we just wanted to make that clear in paragraph 1. The Court. Okay. Mr. Lauro. But I think Your Honor knows our concerns in terms of a blanket order. We think it's much more practical and much more in accordance with the way that this Court has handled these orders is to have the burden on the government at first issue. The Court. Well, they always bear the burden when they move for the order, so I'll hear from Mr. Wyndham in response and then I'll rule. Mr. Lauro. Yes. Mr. Wyndham. Thank you, Your Honor. The government is happy to accept its mandates to bear the burden for good cause here. The defense counsel's made a bunch of comments that are obviously political in nature here in this courtroom. I'm not going to address those. What I will say is that it is emblematic of what the defendant has done even more recently, since we filed a week ago, in posting things about potential witnesses in the case. Counsel also has made no secret about what his intention is. The good cause here is in order to, among what I have already said, to prevent pollution of the jury. The Court. I really want you to focus. This is the first thing. We have a number of things to discuss, and I really want you to focus on the sensitive versus non-sensitive difference and whether it should all be subject to the order. Mr. Wyndham. Yes, ma'am. And the government's aim here is to prevent the use of any material produced in discovery for purposes of harming the jury pool, whether it's sensitive, whether it's non-sensitive. The aims control, the objectives control, regardless of the designation. The Court. I agree, but you still have to show good cause for the non-sensitive. That's really what I'm trying to home in on. Mr. Wyndham. Yes, ma'am. And I cannot be more specific than they have identified what they intend to do with it. Even if it is non-sensitive material, it still has the potential to pollute the jury pool. It still has the potential to intimidate witnesses, to damage witness reputation. And I would say that this is not. The defense has said this is some sort of extreme thing that the government's reaching for here. The defense agreed to these same protections in the Southern District of Florida not 2 months ago. The Court has entered an order with the same broad brush of covering all discovery in the Butina case in addition to the handful of cases that the government mentioned here in its brief. The Court. I think the difference with the Butina case, which now seems so small and quiet, is that there was no argument from the defense there that the defendant in that case needed to speak, and we have a different situation. As I said to Mr. Lauro, the fact that there's a political campaign going on is not going to influence my decision one way or the other, but I do have to weigh the defendant's, all limitations on a defendant's First Amendment rights, and I would point out that even without the protective order, the defendant Mr. Trump is subject to pretrial release conditions, which also prevent him from interfering with the orderly administration of justice and engaging in behavior that could harass or intimidate a witness, because the release conditions are also there. Mr. Wyndham. That's also correct. What the protective order does is to limit the amount of information and data that the defendant would be able to use in the event he wants to go after a potential witness. The Court. And so the statement that you used, where the defendant posted something about the former vice president, for example, that really wouldn't be covered, right? Because that's not really information. That's covered under his conditions of release. Isn't that right? I mean, that's not from information that would be turned over in discovery. That's behavior that may be affecting his conditions of release, but not really implicated on the protective order. Mr. Wyndham: That's correct. However, once the defendant receives discovery, if he says something that clearly he got from a transcript or from another document, the court: Well, we'll get to it, but a transcript may be designated as sensitive, so it's subject to the order. I'm really trying to determine if I need to subject the non-sensitive information to the order, and that's where I keep getting a lot of broad arguments, but I'm not, Mr. Wyndham, sure, and it's a little hard to speak in the abstract, which is why... The court: I know. Mr. Wyndham: In addition to the overriding principles that the government has laid out, I guess I would say two other things. First, in paragraph 1 of the proposed protective order, the government's order is appropriately limited. It does exempt information that is public. It does exempt information that the defendant or defense counsel comes into possession of by independent means unrelated to the discovery process. So we are talking about, in terms of the non-sensitive versus sensitive, we're talking relatively small percentage of discovery. But nonetheless, the concern is that the defendant will still use that in order to effect the fair administration of justice to the extent that there is... Once we get the ability to be more granular, once discovery is produced, to the extent that there is an issue where there is a strong defense reason to rebut the government's good cause that we have set forth, the defense can come back to the court. The court: All right. Thank you. Mr. Wyndham: Thank you, Your Honor. The court: It is close. But as I said, there are release conditions, and the government has an opportunity to, before turning over discovery once the protective order is issued, to go over its materials and add sensitive designations. So at this point, I am not persuaded that the government has shown good cause to subject to the protective order all the information in this case, and therefore I will adopt the defense's revised scope. The protective order will govern only materials that the government designates as sensitive. At this stage, as I said, I'm not persuaded. I will tell you, Mr. Lauro, that as I just said to Mr. Wyndham, the defendant is also covered by conditions of release, and all his behavior and statements are governed by those conditions of release. So regardless of whether statements are made that are derived from the discovery or not, if they are made and they have an effect on the administration of justice or have the effect of intimidating or causing harassment to a witness, I will be scrutinizing them very carefully. All right. The remainder of the disputes about the protective order are largely confined to the defense's discrete edits in the particular paragraphs. So as I said, I'm going to go through them in sequence as they appear in Exhibit A to defendant's opposition brief in ECF number 14, beginning with paragraph 1. I cannot accept the defense's edit that would exempt from the protective order any records that, and I guess you would, that would exempt from the protective order any records that, in quotes, become publicly available. Discovery materials could become publicly available through any number of ways, some improper. I am not willing to automatically allow the parties to disclose or confirm any materials just because, for instance, someone else manages to access and disseminate that information. So I'm not going to go for that edit, and the government language will stay. Instead, I will retain the government's proposed language, which exempts only records that are publicly available independent of the government's production. If certain records that are not publicly available now become so during the course of these proceedings, the defense may move to modify the protective order to exempt them. Next, we move to we're still in paragraph 1. I also cannot agree to the defense's other proposed edit to paragraph 1, which would exempt records which the defense came into possession by other means other than government production. As the government points out in its reply, that would allow the defense to subpoena sensitive information learned through discovery and then disseminate those materials, and I don't want that to happen. So I will therefore retain the government's proposed language, which exempts only records that the defense obtains by independent means unrelated to the discovery process. I move now to paragraph 3. Mr. Lauro: Your Honor, if I may. The court: Yes. Mr. Lauro: I don't mean to interrupt. Will the court adopt our request that it should be records or information to cover the Seattle Times issue? The court: In paragraph 1? Mr. Lauro: In paragraph 1, yes. The court: Mr. Wyndham? Mr. Wyndham: The government has no objection to that, Your Honor. The court: I will. Mr. Lauro: Thank you, Your Honor. The court: Okay. Paragraph 3. The defense proposes broadening the definition of authorized persons who can view the protected materials to include not only persons employed to assist the defense, but also to any persons assisting the defense in any capacity, and I quote, including any attorneys, investigators, paralegals, support staff, consultants, or expert witnesses who are advising or assisting defense counsel. I am not comfortable with that broad a definition, which could include just about anyone and would significantly heighten the risk of unauthorized disclosure, so I'm not going to alter that definition. I do note, however, that the parties' briefing suggested that the defense might be amenable to drafting a narrower definition to which the parties could agree. Do you have a proposed alternative, Mr. Lauro? Mr. Lauro: We could submit one, Your Honor, yes. The Court: And obviously submit it to the government first, because to the extent that there's anything that is unopposed, I'm going to treat it much more quickly than I would if it's opposed. So I would appreciate it if you would do that. Mr. Lauro: Your Honor, may I speak to that issue, though? The Court: Yes? Mr. Lauro: I'm assuming and want to represent to the Court that anyone on our team who has access to any discovery will be given a copy of this order, and we will require them to abide. The Court: Actually, I'm going to get to it, but I'm going to add a provision that neither party had mentioned, that they sign a document. Mr. Lauro: Yes, and we understand that. But one thing we want to be able to do, obviously, is as we build our team with this incredibly large case, to be able to have, consultants and others who are working under our direction or with us, including in some instances people who volunteered to be volunteer lawyers and volunteer paralegals to assist us. They'll all be subject to this rule and subject to Your Honor's order. This is a massive case, and it's impossible to get ready under the terms that the government is seeking, which is in early January, without the kind of staff. The special counsel, as I understand it, has over 60 lawyers and investigators working on this. We have a relatively small group here. The Court: I understand, Mr. Lauro, and it's an impossible task unless we're able to enlist the help of people who are willing to abide by Your Honor's ruling, abide by this order, abide by the rules of the Court, but who want to provide assistance. In order for us to defend this case, we have to have more help and more manpower beyond just the lawyers working on it. The Court: I understand that. And no one is more aware than I that you and your team are defending Mr. Trump in more than one jurisdiction at the same time. I'm aware of that. Notwithstanding that fact and the need for you to obtain assistance, there's a process. I cannot accept a definition that would basically let anyone, including, I might note, individuals who may be unindicted co-conspirators, to assist and to have access to this material without leave of court. If there is a lawyer or legal personnel, a paralegal or lawyer or consultant that you want to have assist you, then that person needs to fit the definition and be subject to the protective order, and the definition you have currently is simply too broad. It allows just about anybody. I live in Washington. Everyone is a consultant. Laughter. Mr. Lauro: That may be, Your Honor, but not anyone would be operating under the direction of counsel and subject to the order. And if the government would like, they can give us a list of co-conspirators. Obviously, we would. The Court: I'm sure you would like that, but I don't think they're ready for that yet. Mr. Lauro: Yeah, we can exclude those. But to basically disable us from having consultants or volunteer lawyers working on the case would hamstring us in an incredible way. In every large case I've had, and I'm sure Your Honor has had, there have been consultants, trial consultants, third parties that assist in the accumulation and processing of documents. The Court: But those people are usually employed by the defense. They are people who are subject to, they're officers of the court. They are people who are subject not only to your supervision, but they must abide by the rules of this case. But volunteers? You're asking for such a broad definition that it makes me very concerned, and I just cannot have it this open-ended in this broad a definition. Mr. Lauro: These outside consultants are often employed by the client or paid by the client. They're under my supervision, but I don't pay all the consultants. The Court: The payment is less troubling to me than the broadness of the definition. I hear you, and I understand your need to have assistance, but I think allowing your definition would basically allow almost anyone to just sort of come in, and it would increase the chance and the possibility that information subject to the protective order would be improperly disseminated. But I'll hear Mr. Wyndham on this. Mr. Lauro: And, Your Honor, if we could submit, perhaps, alternative language. But I just want to make clear that anybody who sees any discovery in this case, it will be at my direction and co-counsel's direction. It will not be done in a haphazard, the court. Anybody who sees any discovery in this case has to sign a document indicating that they understand and are bound by the protective order. Mr. Lauro, we're fine with that, Your Honor. The court, okay. Well, I'm not going to accept the language as you proposed. As with this order, it is subject to modification. If there's alternative language that you want to meet and confer with the government about, I'll hear you further down. But as it stands right now, I'm going to leave the government language in. I'm not going to change it to the language that you propose, at least in your motion. Mr. Wyndham? Mr. Wyndham, I don't need to be heard, Your Honor. The court. Sometimes it's good to just, move on. All right. Paragraph 4, which is the exception for generalized mental impressions. The government does not object to the defense's proposed exception to paragraph 4 for generalized mental impressions, so I will accept it. With regard to paragraph 5, agreement in writing, I will make one minor edit, as I said, that has not been requested by either side, which paragraph 5 provides that all authorized persons must be provided with a copy of the protective order and agree to abide by it. And I am going to add that such agreement must be in writing. Paragraph 6, exception for work products, etc. The government does not object to the defense proposed exception to paragraph 6 for work product, notes, or other documents reflecting the content of protected materials, and I agree that that edit is appropriate, so I will accept it. In paragraph 7, the defense proposes a similar exemption from the protective order for any records that become publicly available. For the reasons I discussed earlier, I will not add that language here, so that I will not add that edit, and that is for the reasons that I discussed in the information that may become publicly available. So, next paragraph, 8E. The defense proposes 2 changes to the definition of sensitive materials in paragraph 8. In paragraph 8E, they replace recordings, transcripts, interview reports, and related exhibits of witness interviews with information regarding the government's confidential sources or which may jeopardize witness security. The government states that the defense definition would allow disclosure of discovery transcripts and audio recordings of witness interviews conducted outside the grand jury process. Let me ask you, Mr. Wyndham, the transcripts and audio recordings that you're concerned about that are not from confidential sources, well, are the transcripts and audio recordings that you're concerned about not from confidential sources? Because if they are, wouldn't they be covered by the defense's proposed language? Mr. Wyndham, they would be covered by the defendant's proposed language, but let me give you a sense as to what we're talking about. The court. Okay. Mr. Wyndham, during the course of this investigation, it was the government's general practice to audio record witness interviews conducted outside of the grand jury. Those fall into interviews that occurred in preparation for grand jury. They fall into separate interviews conducted outside of the local area. They fall into interviews that occurred at our office. There are hundreds of recordings of witness interviews. What is or is not a confidential source, it's hard to say when you're simply talking about a percipient fact witness, for example, to the defendant's criminal conduct. Our approach is much cleaner. It is the functional equivalent of a grand jury transcript taken outside of a grand jury setting, and what it will prevent is what defense has forecast it's going to do. It will prevent the defendant from putting a post out and attaching a 3-second snippet of an audio recording. It will prevent the defendant from putting out a metro billboard with a quote or sending out a mass mailer targeted to the D.C. jury pool. It will prevent the defense from systematically and scientifically generating the grounds for a Rule 26 motion for change of venue. It will prevent the pollution of the jury pool. That is the import of the government's proposed order with respect to that subparagraph. The court. Are there other materials you're concerned that the defense's proposed language would exclude? Mr. Wyndham. So the government's proposed language covers all of the transcripts and recordings. The defendant's proposed language, we would construe it broadly. We would have to designate all of those transcripts should the court decide to go with the defense here. But I anticipate that it would result in protracted weekly litigation over which sentence of which transcript that the defendant finds favorable that it wants to put out, on the Sunday shows or put through a surrogate. Ours is much cleaner and straightforward and more efficient for this court. The court. Okay. Mr. Lauro? Mr. Lauro. Yes, Your Honor. Once again, it's too broad of a brush. For example, let's assume the government has obtained information, a transcript that came about during the J6 committee, assuming that they haven't destroyed it, and in the course of that, the government has that discovery. It's a transcript. It was never intended to be confidential. For whatever reason, the J6 committee did not decide to release it, but there never was any degree of confidentiality attached to it. That clearly should not be designated as sensitive information, particularly if it contains Brady or Giglio material that would be very important to President Trump in terms of his defense and in terms of the wider scope of what he has to do to defend himself publicly. The court. But again, you're sort of conflating what your client needs to do to defend himself and what your client wants to do politically. And your client's defense is supposed to happen in this courtroom, not, on the internet. Mr. Lauro. Well, and here's the court. And to the extent your client wants to, make statements on the internet, they have to always yield to witness security, witness safety. And that's what I'm concerned about. The subcommittee may not have designated those transcripts as confidential, but you start releasing snippets of witness interview transcripts, what do you think is going to happen to those witnesses? Mr. Lauro. The problem is, Your Honor, the way that this is drafted. If President Trump talks about something relating to that witness and it happens to be in a transcript, then they throw the red flag and they say there's been a violation. The court. Well, I'm finding it very difficult to envision the former president of the United States engaged in a political campaign talking about potential witnesses who may not have, the kinds of protection that he has. I mean, I could see the possibility for a lot of problems here. I'm not sure what right. Your client retains, as I said in the beginning, a First Amendment right. But I can see how, in advance of trial, making public statements about potential witnesses is going to, in and of itself, affect the orderly administration of justice, and Mr. Lauro could run afoul of his release conditions. So the example you're giving me is not helping. It's actually causing me some concern. Mr. Lauro. And I understand your concern, Your Honor. And President Trump will scrupulously abide by his conditions of release, and we will do everything to ensure that that happens, and it will happen. But let's take one example. Vice President Pence is a political opponent now in a campaign, and there's going to be an exchange between the two of them. There's going to be arguments back and forth. And if in one of President Trump's statements it happens to overlap with something that's in discovery that's included in this definition, we suddenly have a problem. And the other thing, Your Honor, respectfully, is President Trump, in the middle of a campaign, should not have that chill over him in terms of the way that he campaigns and advocates for his position. The court. He is a criminal defendant. He's going to have restrictions, like every single other defendant. This case is proceeding in the normal order. I know there are obviously security concerns, and there are many, many concerns that we all have because of the unusual nature of this case. But the fact that the defendant is engaged in a political campaign is not going to allow him any greater or lesser latitude than any defendant in a criminal case. Mr. Lauro. We understand that, absolutely. But the problem is, the way that this order is written by the government, it paints too broadly. All we're asking for is more specificity, particularly with respect to sensitive information that the government can designate with some particularity and have a reason for. Simply saying a transcript is sensitive, that's not enough under Your Honor's original determination, because there's no good cause to identify that particular transcript as sensitive. Once again, we have to go back to the government showing good cause, why it's sensitive, and why it should be protected. That's all we're asking for. The court. Well, what I did in the beginning was agree with you that the government has to show good cause here for why certain materials should be covered by the protective order and shouldn't, and I agreed with you that, as to the non-sensitive information, it would not be covered. But now we're talking about what can be designated as sensitive, and I have to tell you, so far I'm not being persuaded by your argument that witness transcripts or recordings of witness interviews shouldn't be sensitive for the reasons I have concern, and the examples you're giving me are not comforting. But I'll hear from Mr. Wyndham on this. Mr. Lauro. If I may say one last thing, Your Honor, respectfully. The court. Yes. Mr. Lauro. I think the government can easily identify what they believe are sensitive transcripts, videos, and so forth, and have some basis for making that argument based on Your Honor's order here. That's something that they're capable of doing. Rather than having this broad category, all we're asking is that the government have to be put to its burden to identify what's sensitive. The court. All right. Mr. Wyndham? Mr. Wyndham. Thank you, Your Honor. The government's proposed order is much more specific than the defendant's proposed order. The defendant's proposed order is subjective and nebulous as to what is a confidential source or what could jeopardize safety. Ours is demarcated by the type of document it is. The defense just said that the government should have to identify which transcripts or audio recordings are sensitive and which are not. Every single one of those people we interviewed is a potential trial witness. All of them are sensitive. I guess the next argument from the defense would be, well, the government has to go through each one and designate specific paragraphs, designate specific pages. That is antithetical to the smooth and orderly discovery process that this court should impose here for the fair and efficient administration of justice. The court. All right, I am going to retain the government's proposed language. The definition of sensitive materials will include all recordings, transcripts, interview reports, and related exhibits of witness interviews. Disclosure of any of those materials creates too great a risk that witnesses may be intimidated or that prejudicial information reaches the jury pool. Mr. Trump is already bound by his conditions of release to, and I quote, not communicate about the facts of the case with any individual known to him to be a witness except through counsel or in the presence of counsel. That's ECF number 13 at 3. But I am concerned that members of the public, in addition to the concerns I've already talked about with regard to witness security, I'm concerned that members of the public who are not bound by the release conditions and by these terms might use sensitive witness information in ways that intimidate witnesses or otherwise threaten the integrity of the proceedings. So I am going to go with the government's definition of sensitive materials. Again, the order provides that either side may seek modification. Moving on to paragraph 8F, which concerns materials obtained from other governmental entities, the defense also proposes to change the definition of sensitive materials in paragraph 8F. Specifically, they seek to exclude the category of materials obtained from other governmental entities. Mr. Wyndham, I'm not sure I understand exactly what would fall into this category. Can you give me an example? Mr. Wyndham. Yes, ma'am. So paragraph 8E really was targeted at the SCO, the special counsel's interviews. Paragraph 8F is mainly dealing with a few things. The first bucket is the material that we've obtained, or that we did obtain from the House Select Committee. There are non-public items that the House Select Committee provided to the government, including transcripts of witness interviews that we do not believe are public. The court. But those will be covered by the previous paragraph, right? Mr. Wyndham. And perhaps this is poor wording on our part. The intention was for 8E really to be focused on what the government's own interviews and for 8F to encompass the Select Committee's interviews. I see that it could be covered by both, so that is one category. The second category is there's a large volume of material obtained from the Secret Service, including internal emails, which have, the names of individuals, various things that the defendant may or may not have known in his time as president that deal with any number of issues that should be non-public. Again, the blanket designation, the government believes, is appropriate for the reasons of not polluting the jury pool, not intimidating witnesses, not naming people who are within the service or within other governmental agencies. Should there be a specific document, we're happy to discuss that with the defendant under the paragraph 16 of the proposed order after discovery is released. The court. All right. Mr. Laro. And, Your Honor, that clearly can be something they designate as sensitive. The court. I'm sorry? Mr. Laro. I'm sorry. It clearly could be something they designate as sensitive if it's a Secret Service or other matter. But to just have it as this broad category, automatically sensitive, kind of, the court, well, it fits the definition, and wouldn't you agree, or do you agree that some of this material under 8F would already be covered under 8E, such as the transcripts of witness interviews? Mr. Lauro. Yeah, it could. The court. What about the material that Mr. Wyndham just referenced, for example, Secret Service emails? That would fit the definition of 8F. Materials from other governmental entities, and that is very sensitive. Mr. Lauro. Right, and it should be designated as sensitive, and they can do that. But what I'm concerned about is non-sensitive information that is swallowed in this broad language of anything that's obtained. It makes it impossible to comply. That's our problem. The court. Well, I may one day regret saying this, but the parties are always free to seek modifications under the terms of the agreement. But I think, given the examples, and given the good cause argument that I've heard from the government, I am going to retain the government's proposed language. The definition of sensitive materials will include materials obtained from other governmental entities. I am persuaded that disclosure could compromise, especially given the example that Mr. Wyndham has given me, and I can think of others, could compromise the confidentiality of those entities' own proceedings, and so I'm going to leave the language in as the government has stated. I'm not going to adopt the defense edit. Now, if you want to propose language that narrows this, you're free to meet and confer with Mr. Wyndham about it. Mr. Lauro: I may have to, Your Honor, because it literally would include all of the J6 materials that the government obtained would be subsumed in this provision, again, assuming that J6 didn't destroy any documents. The Court: Wouldn't some of that material already be publicly available? Mr. Lauro: Not necessarily, because the Court, but some of it would. So you said all, and that's not actually correct, right? So some of that material has been broadcast. Mr. Lauro: Talk about pretrial publicity. They had big TV screens going on. But the problem is that we don't know what's there and what's not there. For example, if there's something that was not publicly disclosed that came within J6, then it's all going to be considered sensitive, even though there's not a good cause showing. That's my concern. The Court: I think the government has established good cause for materials that are defined in that paragraph, and, as I said, this order has to be read as a whole. And so there may be some of those materials that are just not sensitive because they are publicly available. And with regard to the subcommittee materials, there may be quite a bit of that is publicly available, given the public proceedings. So at this point, I'm not going to adopt the defense language. Now, paragraph 8, the final edit the defense proposes. Not the final. The final edit to paragraph 8 would require the government to conspicuously mark all sensitive materials. Now, Mr. Wyndham, my understanding is... Well, tell me if I'm wrong. Do you intend to, when you produce the materials, segregate all sensitive materials from non-sensitive materials? Correct? And your reply brief suggests that it would be, you said, logistically unworkable to mark all sensitive materials. Can you explain why? Obviously, if you have to go through and stamp every single page sensitive, that's really quite burdensome. But what about an interim measure, like stamp on the first page, or I don't know? Aren't there some ways that could make sure that the defense doesn't inadvertently produce something that's sensitive that they could argue to me, well, we just didn't know, it wasn't clear that was sensitive? Mr. Wyndham: So this is actually it may not seem on its face, it's a very important point for the speed of getting discovery out. The Court: And I'm all for that. Mr. Wyndham: Yes, ma'am. So what the government wants to do is whether it's in the cover letter or in the source logs, and I have an example where the source logs have the exact production by very organized title and description, the Bates number, and whether it is sensitive or non-sensitive. The Court: Okay. Mr. Wyndham: That is the fastest and most efficient way to accomplish this. The defense has asked for a page-by-page stamping of them. If the Court went with that, the Court: I'm not going with that. Mr. Wyndham: Thank you, Your Honor. I will say that this approach also was adopted in a protective order in a case in which Mr. Lauro was counsel in Florida about 2 years ago, with this language being permissible to include it not just on the face of the document, but also in cover letter or in transmittal information. The Court: And the organization and designation that you describe in cover letter and transmittal would include a Bates range. Is that correct? Mr. Wyndham: Yes, ma'am. It is the source, the beginning Bates, the end Bates, the designation. The Court: All right. Mr. Lauro, I'll hear you if you want. Mr. Lauro: They're going to do what they're going to do. Well, no. I mean, you enunciate a reasonable concern, which is you don't want to be in front of me saying we released sensitive information, but we didn't know. And I want to make sure that you're not in a position where you may do that and that the production is designed so to ensure that there's no confusion. The procedure that Mr. Wyndham has described sounds like it would make clear by Bates range and source and in every other way that, what is sensitive and what is not. I do think that stamping every page would be not only unworkable, but would delay this considerably for a reason that's not really a problem. I don't mind taking the time to ensure that things are done right, but it seems like a solution in search of a problem. Mr. Lauro: Your Honor, based on the explanation that counsel gave, we're fine with it as long as we have identifiable sensitive information that we know exists. The Court: Okay. Mr. Lauro: I just resent the fact that counsel has been searching for prior orders in cases that I had no idea about, so I just need to put that on the record. The Court: Well, I hear you. I feel your pain. All right, based on the parties' submissions and the arguments, I will retain the government's proposed language. I will not require the government to mark every record it designates as sensitive, and I'm willing to accept their representation that individually marking the documents would be too burdensome and unnecessary, frankly, in light of the government's representations as to how they will produce and segregate and designate the documents. Now, paragraph 9, which goes to assisting the defense, and that goes back to our discussion that I had, Mr. Lauro, with persons who are subject to the order. In paragraph 9, the defense edits reiterate the expanded definition of authorized persons that I discussed earlier in relation to paragraph 3, and for the same reasons as my ruling on paragraph 3, I will not accept those edits and am going to leave in place the government's definition of authorized persons. Also in paragraph 9, the defense's other edit extends permission to share sensitive materials to the counsel of persons to whom the materials solely and directly pertain. That edit and revision is unopposed, and I will enter it. Paragraph 10, counsel review of defendant's notes. The defense edit to paragraph 10 would remove defense counsel's obligation to review Mr. Trump's notes regarding sensitive materials and ensure that they do not include any personal identifying information under Federal Rule of Criminal Procedure 49.1. I am inclined to reject that edit. That obligation is imperative, as I mentioned earlier, to prevent witness intimidation and other potentially prejudicial consequences. With regard to paragraph 11, Mr. Lauro, Your Honor, I have one question about paragraph 10, and this really does raise an important issue. If there are transcripts or documents of prior witness testimony, for example, I want to be able to allow my client to read those in private and have the ability to examine them without counsel present or without counsel being in the same room. And I think we have to have some degree of assurance that we don't have to literally sit next to our client while he reviews transcripts and otherwise sensitive information. The Court. Well, and I'll hear from Mr. Wyndham in a minute, but hold on. Court reviewing document. Wouldn't your client be able to review, and Mr. Wyndham can correct me if my reading is incorrect, but he would be able to review those materials in private, but afterwards you would have to check his notes to make sure that personal identifying information wasn't included in those notes. It's not how he reviews the notes. Am I wrong, Mr. Wyndham? I mean, Mr. Lauer's concern is that his client be allowed to review the notes in private. Mr. Wyndham. Just to make sure we're talking about the same thing, the notes or the sensitive discovery materials. The Court. Mr. Lauro, as I understand it, wants his client to be able to review the sensitive material without him having to be there. Is that... Let's break it down. Is that agreeable to the government? Mr. Wyndham. I guess I would first note that Mr. Lauro did not object to that language in paragraph 10 in this proposal here. What it sounds like he's asking for is that he need not sit next to his client the entire time. The Court. Right. Mr. Wyndham. I think as long as it is a person employed to assist with the defense to be with him when the sensitive materials are present, and then to collect the material after the defendant is done reviewing the sensitive material. The Court. Hold on a second. Court reviewing document. So your objection, Mr. Lauro, is to the language that says, but defense counsel may not provide a copy of sensitive material to the defendant? Mr. Lauro. Exactly, Your Honor. And we're not, in terms of personal identifying information or that nature, we're fine with it. I mean, we can sit with the client. But in terms of, and other orders, by the way, have done sensitive and highly sensitive differentiations. What I'm saying is, if there's a transcript of a witness or if there's a video, I want to be able to share it with my client without having to sit in the room or having somebody from the defense team sitting in the room with him. That becomes impractical under the circumstances, and it really does impinge on Sixth Amendment rights. We have a lot to do in this case with a relatively small staff, and for us to have our folks sitting with a client as he reads through a transcript, maybe hours, really is an intolerable burden on us. At least allow us to have the client read transcripts, read information that could be relevant to the case, and then coordinate with us and communicate with us. We can put in procedures to get that information back immediately, but we have to have a situation where the client is allowed to review materials on his own outside the presence of counsel. The Court. You didn't object to that part. In your motion, you addressed the notes issue. You didn't address the reviewing on your own issue. Mr. Lauro. Well, that's correct, Your Honor. But in light of the fact of how sensitive information is now defined under this order, which will include these transcripts and interviews and so forth, the issue does come to the forefront, unfortunately, in terms of dealing with that issue. The Court. Okay. Mr. Wyndham, Mr. Lauro has a point, which is, tell me what it is you're worried about. So I'm already inclined to have the order require that the defense inspect any notes. So that would apply whether or not Mr. Trump is accompanied by counsel or other legal staff while he's reviewing the material or not. They're still going to have to check all notes that he makes. So tell me the harm or the prejudice that you see arising from him being able to read the materials, which he's allowed to see by himself in another room, as opposed to having one of his lawyers or paralegals or legal staff be there with him. Mr. Wyndham: Yes, Your Honor. 3 things on that. First, defense counsel has a certain level of trust in the defendant that the government does not. Second, the defense counsel agreed to an extraordinarily similar position in Florida. It is defendant shall only have access to discovery materials under the direct supervision of defense counsel or member of defense counsel's team. The Court: But that involves some classified and national security implicated information, doesn't it? Mr. Wyndham: No, ma'am. This particular order that I'm reading from is the non-classified protective order. There's a separate SIPA Section 3 classified protective order. Third, publicly, the defense counsel and the defendant have had a divergence of views on the protective order, whether there should be one at all or not. The defendant says there should not be. Second, the defendant has made claims in the press that his counsel has not adopted with respect to motions that should have already been filed or will soon be filed. There's a delta that I'm concerned about. The Court: But how would, and I hate to interrupt you, but I'm going to, because how, and I share your, but sometimes, I was a defense attorney. Sometimes there is a divergence. But how would the procedure that you're talking about address that? In other words, whether Mr. Lauro or one of his legal staff is in the room or out of the room isn't necessarily going to solve that problem. Can you tell me how it would? Mr. Wyndham: It would ensure that the defendant doesn't have unfettered access to sensitive materials to do with as he wants. The Court: But even if Mr. Lauro... Okay. Say I go with your provision and I require Mr. Lauro, one of his co-counsel or legal staff to be present. If the defendant is going to do something, he can still do it whether they were there or not there. I mean, the safety is the notes, right? Making sure that any notes that he takes are reviewed by defense counsel to make sure they don't include identifying information. Mr. Wyndham: 2 things, Your Honor. First of all, the point of the protective order is to limit risk. It will limit risk in order to have a defense counsel or employee. The Court: How, though? Mr. Wyndham: Because of this. The defendant, when he only has the materials to himself, could elect to photocopy or otherwise reproduce, take a picture of the sensitive materials. That risk is much lower when in the presence of a member. The Court: You mean like live tweeting something? Mr. Wyndham: I mean literally just photocopying or taking a picture of something, having it in order to do whatever he wants with it. He has shown a tendency to desire to hold on to material to which he should not have. The Court: Well, I'll hear you, Mr. Lauro. I'm still having a hard time figuring out how having somebody right there with him is going to, and I hear you about the photocopy or photograph. I guess that's a possibility. But I'll hear your response on that, Mr. Lauro. Mr. Lauro: Yes, Your Honor. I'm quite surprised that counsel would say that because it suggests that really what they want to do is just bog us down and bog President Trump down in the middle of a campaign, and maybe that's what they want to do. But the reality is to have a lawyer physically with a client all the time. The Court: Let me stop you. Actually, Mr. Wyndham, would the government be willing to allow the defendant to review the material, provided that the defendant didn't review the material with a phone or, just without access to those, to the extent that that's a possibility, without access to those? Because Mr. Lauro does have a point. It's a lot of material, and they are stretched. And absent some real danger of what you're saying happens, I think it would be burdensome for the defense to require legal staff there all the time. Mr. Wyndham: The issue really is a custody or control one. I think Your Honor has identified some mitigating measures. Should the defendant not be permitted to have electronic devices, not be permitted to have a replicating machine? The Court: While he is reviewing the material. Mr. Wyndham: Yes, ma'am. And then also the other catch to that is, even though a defense counsel or member of the team wouldn't be sitting there, they would have to be immediately available to collect the material if the defendant goes to lunch. The Court: Absolutely. That's sensitive material that can't be left lying around. Mr. Wyndham: So if somebody is going to be there anyway, outside the room, I'm not sure why they couldn't be in the room. That said, I understand Your Honor's mitigation measures. I have yet to hear. There has not yet been a motion to amend the specific language already employed in Florida, so I'm not sure what the actual aspect of the hypothetical harm here is. The Court. That I forgot to ask you about, Mr. Lauro. You did agree to it in Florida. What's the problem now? And that case involves, as far as I know, I don't know any details, a lot of materials as well. Mr. Lauro. It does, Your Honor, and I'm not involved in the case in Florida. I'm not counsel. The Court. Oh. Mr. Lauro. But the bottom line here is that we have to have a workable system that allows President Trump to review these materials without counsel either sitting in the room or outside the room. We are stretched incredibly thin in this case. The Court. Well, what about Mr. Wyndham's point, which is, I intend to retain the provision that says the notes have to be reviewed, so, Mr. Lauro, we can direct the client not to make any notes, obviously. I mean, this kind of intrusion, the Court. But Mr. Wyndham's point, which is even if the defendant is reviewing notes alone, in a room where he doesn't have access to electronic devices that could reproduce those materials, somebody still has to be present to collect it, safeguard it. I mean, it's still going to require time. What about that? Mr. Lauro. The problem is, Your Honor, respectfully, is the government has not shown good cause for that kind of intrusion into the attorney-client relationship. The Court. But I'm saying, even if he's allowed to review it by himself, it's still going to require staffing to make sure that the conditions of the order are complied with. The materials can't be, they have to be safeguarded and they have to be collected, right? Mr. Lauro. That's the problem with the order as it stands now. The Court. Oh, that's not going to change. Mr. Lauro. No, but I'm just saying the practicality of a case like this, of this magnitude, with the number of documents involved based on what the folks here are requesting, would put President Trump and his defense team at an incredible disadvantage at a time when not only is he facing other prosecutions brought by this administration, but also other litigation. He's in the middle of a campaign against this administration, and to have this kind of burden on us is enormous. And in 40 years of practice, I've never seen a situation in a white-collar case where counsel has to sit next to his client and literally sort of babysit what goes on in terms of what they review and what notes they take. What Your Honor has in this order already are protections that if President Trump made any statements in violation of the order, then that's a problem. But having all of these oppressive kinds of conditions, which they know will interfere with the campaign, that's the goal. They know that. The Court. I'm not going to accept that premise, and again, I'm not going into that, Mr. Lauro. But the practicality of it, the Court. And I will tell you, I think the more reasonable, and what I see is, I see a desire to move this case along. I haven't seen any evidence that this is politically motivated. I understand you have a different view, but it might be more persuasive to me if the former president had not entered into this agreement in the Florida case. It certainly undercuts some of the strength of your arguments that they're already agreeing to do it in Florida. And I'm willing to consider a modification to that, but I am not willing to consider anything that's going to result in information that's sensitive being disseminated to the public. And I have concerns about that, Mr. Lauro. And obviously we will abide by your order, and we understand Your Honor's position. But there has to be some practical way of carrying this out so that it doesn't burden the defense. And as a defense lawyer, it's not easy to sit with a client for hours and hours while they read a document. It just doesn't work, Your Honor. The Court. Okay, I agree with you, and therefore I am going to compromise here. I will allow the defendant to review the sensitive material without being accompanied, without having a member of the legal team sit next to him, but I am going to retain the provision that requires counsel, members of the legal team, to review any notes. And if you're saying you're going to instruct him not to take notes, so much the better, but to ensure that there's no notes taken and no personal identifying information that is kept. And if the defendant's going to review those materials alone, the defendant cannot have access during that review to an electronic device, photocopier machine, or anything that could reproduce or copy those materials. Mr. Wyndham? Mr. Wyndham. Your Honor, the issue remains about keeping custody or control on breaks or lunches and things like that. The Court. Oh, yes. Those materials must be safeguarded. They cannot be left alone. Should the defendant need to leave the room for any reason, someone has to safeguard those materials, and certainly he can't carry them around with him. Okay, paragraph 11. The defense proposed edits would permit the parties to include sensitive materials in any public filing without leave of court if all sensitive information is redacted. This doesn't materially alter the government's proposed approach, which likewise contemplates filing without leave redacted sensitive materials. I will allow the parties to include in their public filings redacted sensitive materials without leave of court, only if they have conferred and both sides agree to the redactions. I realize that exception may swallow up my ruling, but if the parties disagree about the redactions, leave of court must be sought before the filing. Again, with paragraph 11, filing sensitive materials under seal without leave, the defense similarly proposes an edit that would permit the parties to file unredacted copies of sensitive materials under seal without leave of court. I'm not going to accept. This edit is in violation of our local rules. Local Criminal Rule 49F6I1 provides that no document may be sealed without an order from the court. In accordance with that rule, I will require the parties to follow the regular procedure for seeking leave to file a document under seal each time they wish to do so for sensitive materials. I will also require that any motion for leave to file sensitive materials under seal shall attach a redacted copy of those sensitive materials so that the clerk of the court can file the redacted copy on the public record if I grant the motion. And I've consulted, and the clerk of the court is prepared and able to do that. Paragraph 12, introducing sensitive materials under seal without leave. So the defense's edits propose essentially the same approach for handling sensitive materials at hearings as they do for filings. That is, the parties may 1. Introduce redacted sensitive materials without leave, and 2. Go under seal to introduce or discuss unredacted sensitive materials. My approach to those procedures in hearings will be the same as it is for filings. The parties may introduce redacted sensitive materials during hearings without leave of court so long as both sides agree to the redactions. However, they may not go under seal or introduce unredacted sensitive materials during hearings without first seeking leave of court, and that's unredacted. Paragraph 12, handling sensitive materials at trial. The defense proposes an edit stating that the court will determine the appropriate handling of sensitive materials at trial in a future order. And I'm not going to add this language at this juncture, but as we get closer to trial, the parties can move for modifications to the protective order that will change or specify different provisions for trial. So are there any proposed or disputed edits from the defense, Mr. Lauro, that I haven't covered? Mr. Lauro: I don't believe so, Your Honor. The Court: All right. Mr. Wyndham, is there anything else? Mr. Wyndham: No, ma'am, thank you. The Court: All right. I will issue a protective order consistent with my decisions in short order, but for now, I just have a couple more items of business. First, as reflected on the docket, last night I denied a motion from the government for leave to file a document under seal and ex parte. I intend for this case to proceed in the public record as much as possible, and the motion did not persuade me that there was a need to file the document ex parte. Accordingly, neither that motion nor its attached document had any bearing on my decision today, and that's why I denied it without prejudice. Going forward, I want to underscore that any motions to file under seal, especially ex parte motions, must articulate the need for those designations, and I will carefully weigh the relevant factors to ensure that there's sufficient reason for keeping any material off the public record. Second, yesterday, the government moved to schedule a conference under the Classified Information Procedures Act, SIPA, to discuss what they said was a small amount of classified information that may be subject to discovery in this case. That's ECF number 25. The government proposes that we hold that conference on August 28th, which is the same day we have our next status conference in the case. Mr. Lauro, are you available to do that? It makes sense to me. We could do it in the afternoon or, right after the status. Mr. Lauro: I think since we'll see you on the 28th, it might be a good time to discuss that as well, Your Honor. The Court: Excellent. Then we'll do it then. Okay, so I will schedule that conference. Actually, it'll just be part of our status conference on the 28th. I don't think I need to schedule another conference. This is a good time to mention that, in the interest of efficiency and in keeping with my standard practice, I expect the parties to confer before filing any non-dispositive motions and indicate in the caption whether it is opposed or not, and that way I can move speedily with regard to unopposed motions. So just say, defense opposed, defense unopposed motion, or say in a paragraph that the government opposes it, and then I'll know to give time and have a briefing schedule. All right. Any other matters related to discovery or pretrial motions that we need to discuss, Mr. Lauro? Mr. Lauro. Yes, Your Honor. If I may approach? The Court. Yes. Mr. Lauro. Your Honor, we've asked the government not to hide the ball and tell us how much discovery there is. They won't do that. We don't know if it's terabytes, multiple terabytes, how many boxes, how they're organized. It's a humongous task, and Your Honor has been there as defense counsel and knows what it's like dealing with something like this. We would like a Rule 16 conference with the government as soon as possible, no later than Monday at 5 o'clock, where we can discuss these issues, because we have to respond to Your Honor in terms of trial schedules, and we need to know how much discovery there is. The Court. Well, so here's the thing. It seems to me, and Mr. Wyndham can correct me if I'm wrong, that the government is prepared to give you that information as soon as I enter a protective order. Is that correct? Mr. Wyndham. With respect to the Court, the amount well, tell me. You tell me. Mr. Wyndham. Thank you. If I may? Mr. Lauro. And if I may ask, how much is it? The Court. Well, you may find out, as I said, immediately after I issue the order. Mr. Wyndham. The government has actively been trying to get the defendant discovery for some time now. We are producing, presumably today if the Court enters the protective order soon, the first production. There's an extraordinarily detailed, extensive source log in the same manner the defense is familiar with from the Southern District of Florida case. Lays out exact Bates numbers, the exact organization of the discovery. So that information will be provided in that source log. There is, in addition to that, a hard drive that we'll go over when the defense lets us know which address to send it to. That is the first discovery production. The Court. And let me stop you. Is there any reason why you can't tell Mr. Lauro how many documents? What are we talking about? Mr. Wyndham. Sure, and he'll have it in a letter, by the end of the day. The Court. Okay. Mr. Wyndham. In the first production. If Your Honor would like to hear it on record, I'm happy to provide the information. He's going to have it in a letter within 24 hours. The Court. I'm just saying, is there any reason why we can't go on the record now? Mr. Wyndham. No, ma'am. The Court. Well, go ahead. Mr. Wyndham. So for the first discovery production, the volume of it is roughly 11.6 million pages, or files, which are load-ready, available at length. There's also a hard drive with 2703D returns and extractions from other certain electronic facilities. Those are impossible to paginate or to identify by that. I cannot go into the details because of various Rule 6 or sealing concerns. In general, I will say the material is extraordinarily well organized. Roughly a quarter of it comes from entities associated with the defendant already, and it may be that the defendant has access to that material already. Some of the material is open source. Some of it is also necessarily duplicative just from an organizational standpoint, just to make sure that the defense knows precisely which documents came from where. As I said, this is the same format and the same process that is used in the Southern District of Florida. We anticipate additional productions in the coming weeks, and our goal is to have discovery substantially complete by August 28th. The Court. You heard Mr. Wyndham, Mr. Lauro. I can just imagine your motion for a trial date now. Mr. Lauro. I'm waiting for the deluge, Your Honor. It's going to come. One small point, though. I think Your Honor mentioned that, with respect to filing under seal, we would have to justify under the normal rules. I assume that the government will also have to establish a reason for filing anything under seal in terms of the Court. Rules apply to both sides. Mr. Lauro. Thank you. The Court. I assume if it's sensitive material, they have to file it under seal. They don't have to give additional reasons if it's sensitive material, as defined under the order. Mr. Lauro. All right. The Court. Okay. All right. Thank you, all of you, for your preparation and attention today. Before we continue, I just want to make 2 points about this case going forward. First, as I have said before, I am committed to ensuring that this case proceeds in the normal course that our criminal justice system prescribes. The protective order that I will issue is just one example of that. Courts across the country and in this district routinely issue similar orders in criminal cases for many of the same reasons that I've discussed today. The defense has reiterated at length Mr. Trump's First Amendment right to speak about this case and the evidence in it. While I intend to ensure that Mr. Trump is afforded all the rights that any citizen would have, I also take seriously my obligation to prevent what the Supreme Court called in Shepard v. Maxwell a carnival atmosphere of unchecked publicity and trial by media rather than our constitutionally established system of trial by impartial jury. It is a bedrock principle of judicial process in this country, as the Supreme Court said in Bridges v. California, that legal trials are not like elections to be won through the use of the meeting hall, the radio, and the newspaper. Obviously, in Bridges, the Internet hadn't been invented yet. This case is no exception. Second, and relatedly, both parties' briefing on the protective order referred to certain public statements that Mr. Trump has made in recent days. There are no motions based on these statements, nor does the government claim they violated the defendant's conditions of release, so I will not address them specifically, but I do want to issue a general word of caution. As I have stressed at several points during this hearing, I intend to ensure the orderly administration of justice in this case, as I would with any other case, and even arguably ambiguous statements from parties or their counsel, if they could reasonably be interpreted to intimidate witnesses or to prejudice potential jurors, can threaten the process. In addition, the more a party makes inflammatory statements about this case, which could taint the jury pool or intimidate potential witnesses, the greater the urgency will be that we proceed to trial quickly to ensure a jury pool from which we can select an impartial jury. I caution all of you and your client, therefore, to take special care in your public statements about this case. I will take whatever measures are necessary to safeguard the integrity of these proceedings. I'll see you all on August 28th. We are adjourned. Proceedings adjourned at 11:39 a.m. Certificate. I, Brian A. Wayne, official court reporter, certify that the foregoing pages are a correct transcript from the record of proceedings in the above entitled matter. Signed, Brian A. Wayne. This concludes this episode of The Docket. I hope you enjoyed this audio version of the transcript of a motion hearing before Judge Tanya Chutkan. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.